My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado. And this is your free consultation on why the police roadside tests don't show impairment by marijuana. So you know what the roadside tests are. They're also known as the standard field sobriety tests. They're the tests that a police officer runs someone through on the side of the road. That's where the name roadside comes from, if they suspect them of being under the influence of either alcohol or drugs. Now there's typically three tests that we talk about. There's the walk and turn, so you walk in a straight line, couple steps heel to toe, turn around at the end, come back. The one leg stand, it's exactly what it sounds like. You stand on one leg for a period of time, count to a number. And then there's the horizontal gaze nystagmus test, and that's the test where the police officer holds up something, usually a pen, in front of someone's eyes and then runs it back and forth. You have to follow that pen, and then the police officer is looking to see if their eyes vibrate at the edge of their gaze, and that's what's known as nystagmus. It's supposed to be an indicator of impairment. What's important to remember about these roadside tests is that they were designed and validated for alcohol. They weren't designed and validated for drugs, and they weren't designed and validated for marijuana, although that doesn't stop the police from administering these tests to anyone and everyone that'll agree to do them, including those they just suspect of using marijuana. So why is this important? Well, on April 5th of this year, 2021, the National Institute of Justice, which is the research and scientific division of the Department of Justice, released a study, and that had some pretty damning findings when it came to the police use of these tests for people suspected of marijuana alone. And specifically, what that study found was that these roadside tests do not correlate at all to somebody's level of marijuana use. So they had 20 study participants. They had them consume marijuana in different forms, orally through edibles, and also by using a vape pen. They had them consume marijuana in different amounts, all the way up to 25 milligrams. And they tested those individuals to see how they did on these roadside maneuvers, and they also tested their blood to see what level they were at when they were administering these tests. And specifically what they found was that the level of cannabis in someone's system did not correlate to their cognitive or psychomotor impairment. Now this wasn't the first study along those same lines. This comes on the heels of a 2013 study by the American Automobile Association that made similar findings. Specifically, they were evaluating drivers who were arrested for DUI based on the state's per se limit for marijuana use. And they found that there was no objective threshold that existed showing someone's impairment based on THC concentrations in their blood. This is important in Colorado because Colorado has a 5 nanogram law for THC concentration in someone's blood for their DUI charge. Now it's not a per se law, the same as alcohol. What it is a permissible inference. So that means that if you are accused of driving under the influence based on marijuana consumption and you go to trial, then the jury gets this instruction that says that they can infer based on the test that you were substantially incapable of safely driving a motor vehicle because the amount of delta-9 THC in your system within 2 hours of driving was above 5 nanograms per milliliter of blood. Now there are rules about what kind of scientific evidence can be admitted at court at a trial. And these rules come from a Colorado case called People v. Shrek. And the hearing that determines if this kind of scientific evidence can come in is known as a Shrek hearing. So there's different standards for that. The prosecution has to show that the scientific principles underlying the evidence is reasonably reliable. And for marijuana, they're not. These roadside tests have only been validated for the use of alcohol, And there's these additional studies by government entities, government agencies, showing not only that they're not reliable, but that they don't correlate at all to this arbitrary number. The prosecution has to show that the expert that they want to use is qualified to render an opinion on that scientific evidence. And when we're talking about these roadside tests, that expert is normally going to be a police officer, so not a scientist. And that officer may or may not be familiar with the studies that they use to validate the roadside test for alcohol. At any rate, it doesn't matter because those tests were never used to evaluate the reliability of those maneuvers for marijuana. Prosecutor also has to show that the testimony is going to be helpful to the jury. And this kind of testimony might be helpful to the prosecutor, but bad scientific evidence is not going to be helpful to the jury. Finally, the prosecution has to show that the probative value of the evidence outweighs any danger of unfair prejudice. And again, the probative value of this evidence is going to be little to none, since it doesn't show anything regarding someone's impairment by marijuana. And the unfair prejudice is going to be extreme if you're asking a jury to believe that somebody is guilty or is impaired by marijuana based on their performance at these tests, which don't show someone's impairment by marijuana. So ultimately, what does this mean? Well, anytime the police are going to accuse somebody of a marijuana-only DUI and are going to put them through these roadside tests and try and use that as evidence, these tests need to be challenged. They need to be challenged on the grounds that they're not scientifically reliable. And the police officer himself or herself, that person needs to be challenged on their qualifications and their scientific knowledge. If the prosecutor is going to try and use a toxicologist, so somebody that evaluated the blood taken from the person accused of that marijuana DUI, and have them try and render an opinion that they were impaired based on either the level of marijuana or THC in their system at the time the toxicologist did that test, or based on their performance on the roadside maneuvers, because the toxicologist will try and do both, that person needs to be challenged based on their familiarity with the relevant scientific literature, specifically this recent study, and they should be forced either to admit that there is no correlation between the level of THC in someone's blood and their impairment, or deny it and contradict this study by the most prominent government agency that they rely on to do these tests. Ultimately, any jury that's going to be deciding an issue of somebody's guilt based on a marijuana-only DUI needs to know that this 5 nanogram number has no scientific value at all. It's a number that the legislature pulled out of their hat when they were rendering this new law. It was done because there were a number of police organizations that were putting pressure on them to have some kind of number in place, and that's ultimately not good policy making and not good law. Now, the only way to challenge bad law based on bad science is with good science, and that should be done every time one of these marijuana DUIs comes up. If you're interested in reading any of these studies yourself, or if you want to see the actual jury instruction that judges give in Colorado that shows this permissible inference for DUI cases, those are linked in the description below. There's also a useful cheat sheet that you can review that covers all of these same topics. My name is Austin Lux. I'm a criminal defense attorney in Colorado Springs, Colorado. I believe in the Constitution. I want you to know your rights and know the law.